Mr. Murali.
Mr. Deputy Speaker, sir, I declare my interest as a lawyer whose primary practice is in litigation. I support the purpose behind the bill, which is primarily to enhance the efficiency of the administration of justice whilst ensuring the litigants' legitimate interests are taken care of as well. I have 4 queries on the bill. First is in relation to the application to adduce fresh evidence on appeal. The proposed Section 30, read with the 6th schedule, allows a judge of appeal sitting as the Court of Appeal to decide on an application to adduce fresh evidence in proceedings before the Court of Appeal. Now, by way of a comparison, in relation to an application for extension of time to file a notice of appeal, a 2-judge panel will hear the matter. The proposed Section 36, subsection 3 of the SEJA provides that a full Court of Appeal can discharge the order. However, the application to discharge or vary the order made by a judge of appeal can only be done with leave in the first place by the judge of appeal. And an order of a judge of appeal sitting alone refusing leave to adduce fresh evidence is final. So, given that the issue of whether or not to adduce fresh evidence can potentially have a bearing on the appeal, may I please ask what's the rationale of putting this issue before a 1-judge Court of Appeal? My concern is we may have a situation where a judge of appeal, at first instance, refuses to give leave, and then he then entrenches his decision by refusing to give leave for an application to discharge before a full Court of Appeal. Then we would not have the possibility, however remote it may be, that a judge of appeal may get it wrong, and then there's no avenue to revisit his Honour's decision. Next, I asked about the policy of vesting amending powers with the Minister as compared to the President. As members of this House would appreciate, our government follows the Westminster model, and judiciary is a separate pillar of the government. The proposed Section 83, subsection 1 of the SEJA vests with the Minister the powers to amend the 3rd, 4th, 5th and 6th schedule via the Gazette after consulting the Chief Justice. This compares differently with Section 34, subsection 3, where it's provided that the President may, after consulting the Chief Justice, may amend the court's jurisdictional money limits, again via the Gazette. May I please ask what's the legal policy in deciding whether the Minister or the President is involved in exercising these amendment powers via the Gazette? My respectful opinion is that the good thing about using the Minister is that the Minister is ultimately accountable to Parliament. And that, I believe, is a point that the Honourable Member, Mr. Louis Ng, made earlier. Next, on the provisions allowing the Court of Appeal to decide via documents without the need for oral hearing. I note that Section 34A, subsection 2, restricts, or may I rephrase, I note that Section 34A, subsection 2, deals with appeals from the SICC. May I please ask for clarification, would the prospect of dealing with documents-only appeals also extend to other divisions of the High Court? And in relation specifically to the SICC, I note that it is provided that a documents-only appeal may be conducted when SICC issues an order for the same. May I please ask, what are the circumstances in which the SICC would issue an order pertaining to whether or not an appeal should be heard by the Court of Appeal on a documents-only basis? At first glance, in the absence of a consent order, it is rather strange for a division of the High Court to suggest to the Court of Appeal how it should conduct its proceedings in exercise of its appellate jurisdiction. Next, I move to the measures for dealing with unmeritorious or vexatious proceedings. I note that the proposed sections 73A to 73D are in addition to the existing Section 74. The learned Senior Minister of State mentioned about the limitation of the existing Section 74. he pointed out that Section 74 may only be invoked through the application of the Attorney General. I, however, note that the Attorney General can also be an applying party under the provisions that will be introduced. May I please ask, what will then be the interplay between Section 73A to D on one hand and Section 74 on the other hand, where the Attorney General is involved in both? The significant difference is this. Under Section 74, subsection 2 of the SCGA, the High Court has powers to assign a lawyer to the party who cannot afford to pay for a lawyer. This provision is not there in relation to the new Section 73A to D. So may I please ask why the same is not provided, given that the Attorney General could be an applying party for either of these provisions? The equality of arms issue is a real one. Finally, on the meaning of legal proceedings under Section 73A, subsection 10, as compared to the existing Section 74, subsection 5. I note that under the proposed Section 73A, subsection 10, the definition of legal proceedings excludes criminal matters. That's not the case in relation to Section 74, subsection 5 of the SCGA. May I please ask why criminal matters are excluded? Now, in practice, we sometimes see vexatious litigants commencing private prosecution, which are criminal in nature. The public prosecutor can intervene for each particular proceedings, but it may be useful to consider a situation where the powers contemplated under Section 73A to D is extended to criminal proceedings so that there could be a general restraint, as the case may deserve. Notwithstanding my comments, I support the bill.